All right, so for those of you on Facebook, we're going live. We have our monthly, our monthly Q&A with Jim. Mackenzie's on her way over here, so we're gonna just give people one more second to sort of get in. We have 38 people on Webinar Jam, and we have 3 people so far on Facebook. If you have questions, go ahead and leave them in the chat over to the right, and I will do my best to answer them. I'm gonna, let's see. Oh, there's our old friend Steve. All right, so I usually do better when Mackenzie fields these for me, but let's see what Noor has to say. So I have a question. I came here on a K-1 visa after we got married, and we did go through the process. I did my green card interview with my wife, and in the same day I did my citizenship test. And have been a citizen for over a year. I just got divorced a month and a half ago, but my ex-wife keeps telling me she's going to hire an immigration lawyer and come after me to take my citizenship away from me. Can't you do something like that? And thank you for what you do. All right, Noor. I don't know that you need to worry about that. It'd be very hard for them to take away your citizenship. They'd have to show fraud. They'd have to show that you lied about something in your citizenship case. It has to be material, which means it has to be something important to whether or not they would have given you citizenship. So if she can prove that you were engaged, can you turn that light on for me? If she can prove that you were engaged in illegal activity at the time that you naturalized and you did not advise them of that, then they might be able to. But and I will say there is a denaturalization unit at USCIS right now, but I don't think you need to be too worried about that. Most immigration lawyers I know would not help her try to take away your citizenship. I certainly wouldn't, and we have a rule in our office that we're not going to do that. So I hope that's helpful for you, Nora, helps put your mind at ease, but I think it's going to be pretty hard for her to get USCIS that interested in your case unless she can show some kind of fraud or criminal activity on your part. All right, so I just started at the bottom with Nora, and I'm working my way up. So if you want to filter for me, and I'll do one more, and then you can get settled in.
Okay.
Cool. All right, my trusty sidekick, Mackenzie's here. Can you say hi?
Hi.
She's here. We had to run over to my office to try to get this thing going. All right, so Will McCarthy. I've been married to my wife for the last 3 years and together in a relationship for a total of 12. She's 33 and lives in Dominican Republic as a part-time student, and I'm a 43-year-old U.S. citizen looking to submit the I-130 spousal application so she can come to live with me in NYC. How will the public charge affect us? 100% financially support her since our relationship began in 1998. She has no income apart from what I send her. Also, she speaks mostly Spanish and knows some English. Please let me know. Well, Will, I think that's going to be a tough case to get approved. USCIS, as you know, is looking for ways to deny people. The embassy is looking for ways to deny people. I think that with the new requirements for the I-944, which is the petition of self-sufficiency, there are a list of factors that come into play as to whether or not someone gets their citizenship or gets their green card, whether they are admissible to the United States. I think it's going to be very hard for you to pull that off without a lawyer. I think that it's going to be a hard case to win. Basically, the Trump administration has declared war on people who don't have a lot of education or work background. So if you've been providing her financial support for 10 years, I think you're going to have to get her enrolled in school, learning English better. I think there's a whole set of things that you can do to sort of strengthen the case, but that overall, it's going to be a tough case to get approved, Will. All right. You got one for me?
Yes. Pamela said that my SIL received his interview date. I co-sponsored him. Do I have to be at the interview?
Say that one more time.
My SIL received his interview date. I co-sponsored him. Do I have to be at the interview?
No, no. If you file an affidavit of support either at the embassy level or at the USCIS level, you do not have to appear for the interview itself. They might send you some questions, but by the time they schedule the interview, they are satisfied with the affidavits of support, and that would not be necessary. Just real quick, before we get to our next question, can somebody let me know, could you guys hear Mackenzie when she was reading the question? Otherwise, I'll repeat it, but can you guys let me know in the chat if you were able to hear her when she read me that question about the affidavit of support? All right, we're just going to wait until everybody. All right, Will could hear you. All right, thanks, guys. All right, next up. Don't forget Facebook, too.
Oh, yeah.
But you're good. Let's see here. I'll take one.
Waleed asks about I-130 that's been processing for 12 to 16 months.
Okay. Waleed filed his I-130 for his wife in Tunisia. He's a U.S. citizen. Processing times are 12 to 16 months. He's 13 months now. Shall I file a lawsuit on USCIS or wait the 16 months, then do it? Also, please, how much will it cost to file a mandamus? Then to help me with an NVC process, please. No kids, just me and my wife that is overseas. So for a lawsuit, a writ of mandamus against USCIS and the State Department, 13 months is a long time. You might wait a little bit, but they should have adjudicated the I-130 at USCIS by now. And the fact that they haven't tells me that it's going to be problematic. Plus, you're trying to bring a woman from Tunisia, which is one of the countries that they delay on. Keely, I'll try to talk a little bit louder. Sorry. We're dealing with some technical issues here, but so anyway, Waleed, I think you could sue them now. You might want to wait a little bit longer, or you might want to wait till the case gets to the National Visa Center. But that's ridiculous that they're taking that long. And I take the position that if you've been waiting a year, that you can go ahead and sue them. The legal fee to file a writ of mandamus, the filing fee is $400, and our legal fee is $3,600. So it's $4,000 altogether. If you want us to take over the case at the National Visa Center and through the embassy, that's a whole other fee. And that depends on the circumstances of each case. So we could talk about that. But if you or anybody else wants to find out about that, just send an email to info@hackinglawpractice.com. And our team will follow up. What's next?
Okay, Ahmad asks, if you mistakenly mention less income in an affidavit of support but have more income than required, what do you do?
If you mistakenly list too little income in your affidavit of support, I'd be interested to find out sort of how that happened. So one thing that I see people get in trouble with is if they file an affidavit of support that is inconsistent with their taxes. In other words, if you had cash income that you didn't report on your taxes, then you're going to need to be careful to report that on your affidavit of support. So I'm a little bit worried by the statement that the income was stated too low. So you might need to file an amended affidavit of support. You might need to update that. And most importantly, you want to be honest with everything. So you don't want to be misleading or tricky or sneaky or inconsistent with your IRS documentation. So you might want to leave that alone. You might want to fix it. But at the end of the day, the standard is, and what you're looking for is to do it honestly and truthfully. Okay? All right.
Sam G said that his fiance's K-1 interview is April 22nd. Does he need his 2019 tax returns, or can he use the last 3 years without 2019?
Yeah, that's a gray area, Sam. So when you get to the embassy interview stage, I mean, if it were me, and Sam's question was, he's in this sort of no man's land between years, and his fiance is going for her interview at the embassy 7 days after tax returns are due. If it were me, I would do everything I can to file this year on time by April 15th and have that in her hand when she goes to the embassy, because otherwise they're just going to give her a checklist or a request for evidence. They're going to ask her for more stuff, and I think it's going to be problematic. So why not just go ahead, get your taxes done by April 15th, and then make sure she has a copy.
Matt on Facebook said that he stayed outside of the U.S. for 6 months and they denied his citizenship case. That was 6 years ago. Can he reapply now?
Say it again.
He applied for citizenship 6 years ago.
Yeah.
But they denied him because he had stayed outside the United States for 6 months.
Mm-hmm.
Can he reapply after 6 years now?
For sure. So whenever you get a green card, there's always two things to keep in mind. One is, how do I maintain my green card and not lose it? And the other one is, how do I set myself up for applying for citizenship? And so the standard is, on the day that you apply for citizenship, they look back 5 years and they want to know, during those last 5 years, has the person lived in the United States for more than 2 years, 6 months, and 1 day? And as long as they have, that case should go through. But if you have a trip of more than 6 months, like, what's his name?
Matt.
Matt had, that's going to be a problem. And that breaks your residency for purposes of citizenship. So there are ways to overcome that. It sounds like Matt didn't do that, which is understandable because sometimes you can't. But after waiting 6 years, as long as you haven't had any trips for more than 6 months, and as long as you haven't spent too much time overall outside the United States, now would be a good time to apply for citizenship.
Okay. I don't know how to pronounce this one. He's on the webinar IHOB.
Okay.
He filed an I-130 on October 4th, 2018. The case was pending in USCIS since then. No updates other than they moved the case from Texas to Vermont on May 23rd, 2019. Is this a normal processing time?
No, if you filed in October of 2018, that means you're at 18 months. That would be one that I would sue for sure. They're just sitting on your case. And so far, these questions that we've had from our friends involving Lebanon and Tunisia, I think you're seeing a trend that from people from predominantly Muslim countries are always going to be subject to extra scrutiny and extra delay. And they've figured out that if they do more delay at USCIS, then they can add more delay at the State Department, and the whole overall case goes slower.
A asks, if a person with citizenship of 3 different countries, which the last one was U.S. citizenship, is there any risk of losing the U.S. citizenship if becoming a citizen of a 4th country?
That's a good question. I don't actually know the answer to that question. If you're a U.S. citizen and you become a citizen of another country. Now, first of all, what's the name of that person?
Just A.
A asks, well, if you become a U.S. citizen, you're giving up your allegiance to your old countries. You're not supposed to have multiple passports from multiple countries. Now, fact of the matter is, a lot of people generally do have an extra passport, usually from their home country. But I think that at the end of the day, if you're walking around or trying to walk around with 4 different passports, the U.S. government's gonna wonder why you're doing that, and that could cause you problems. So I'm not saying you can't do it. I would just say be very careful with that, and I would probably recommend against doing that. I don't know why you need to keep getting citizenship from all these different countries.
Tariq said that he had just gotten his citizenship last week and he wants to apply for his 3 siblings and his parents. Should he have a lawyer to take care of the 5 cases, or should he file himself since he did his case by himself?
Oh, that's a good question. So, Tariq, a couple things. One is your parents' cases and your siblings' cases will not be treated the same. Does he say how old the kids are, the siblings?
No.
Yeah, so if a U.S. citizen sponsors their parents, right now there's an immediate visa available for them. They have an unlimited number of those visas. But for the brothers and sisters of U.S. citizens, that is not going to work. That delay right now is 14 years. So you're going to need to be a little bit creative. It's relatively easy to get the cases approved and processed for your parents, but for your brothers, your siblings, that's going to be a lot harder. So I think that you're overall going to need more help. And the fact of the matter is that with this new requirement, the Declaration of Self-Sufficiency, the I-944, I have personally become convinced, and I'll be glad when people prove me wrong, but I've personally become convinced that individuals will not be able to apply for family-based immigration to the United States without a lawyer involved, because that I-944 is 16 pages. It's very detailed. It's actually harder to fill out than the rest of the forms combined for bringing a family member here, and that is all by design. They want to stop and slow down immigration to the United States legally, and they've come up with this I-944, and that's what they think they can do. So, we're just 2 weeks into the I-944. We're just getting started. Nobody really knows how it's going to play out. Nobody knows whether cases are going to be impossible to approve or possible to approve or somewhere in between. And so at the end of the day, I think the time has come where it's going to be very, very difficult for people to do anything involving adjustment of status or immigrant visas that do not involve immigration lawyers. I don't think that's fair. I don't think that's how things should be. But once an agency takes a lot of power like that, it's going to be really hard to get it back from them.
Sue wants to know if you've had any success doing writ of mandamus on K-1 visas with the Embassy of Jordan.
Yeah. So we've definitely had success with K-1 visas. We've definitely had success with K-1 visa lawsuits. So these are lawsuits against the embassies for delays on fiancé cases. We've definitely had lawsuits against the embassy in Amman, Jordan. I can't remember one specifically other than one where it was both those things, a fiance case against Jordan. But the embassy in Jordan, unlike the embassy in Morocco, seems to be a lot better and a lot more professional. So in the lawsuits we've had with Jordan, those have gone relatively quickly.
Sebastian wants to know, does he, as the petitioner, have to go to the interview at the embassy?
Okay, so number one thing, guys, I want to mention, first of all, this is like the third question of which I have YouTube videos on the channel. So I'm happy to answer questions in the webinar, and the webinar always gives me ideas. But I want you to know that that resource is there. So if you go to our YouTube channel, I did a video about 6 weeks ago to this very question. And the reason I made this video is because nothing good is going to happen if a U.S. citizen goes to the interview. And the reason for that is that they are going to separate you, and then they're going to do what they try to do in some cases here in the United States, separate you, make it out to be that your answers are inconsistent and that you're a liar. So I have gone so far as to telling people not to go visit their spouse in the home country if we think they're going to call you for another interview, because they haven't started yet saying, hey, have the American come to the embassy, like come to the country to go to the embassy. That hasn't happened yet. I think it might start happening. But at the end of the day, nothing good is going to happen if the U.S. citizen attends the interview. It's just going to be used to hurt your case, to deny your case, to do what they can to screw up and slow down your case. So I am a strong believer that at the embassy stage, you do not want the U.S. citizen or the lawful permanent resident sponsor to attend the interview.
Okay.
There's 50 people on here.
I know. So this woman on Facebook said that she had gotten adopted by her U.S. citizen parents, but USCIS kept denying, saying that they don't have enough evidence to give her a green card. She's now in her mid-20s. If she meets someone and gets married and files a new application as a spouse, would that look bad?
Well, first of all, if someone's been here that long and hasn't received their green card based on the adoption relationship with the parents, just the first thing you need to do, and you probably need to do it sooner rather than later, is to send USCIS a form called the G639. A G639 is a Freedom of Information Act request where you can get your entire immigration file. That will be helpful if you're going to go through the process with a spouse. So the first question, of course, is how did you enter the United States? So sometimes with adoptions, kids enter the United States in strange ways. So one big question as to whether or not you're going to be able to adjust based on marriage to a U.S. citizen is how did you enter? And then we got to scrutinize that. And then, of course, you have to demonstrate that the marriage is legitimate. So if you can show those two things, the fact that you've been trying to get it through adoption should not in and of itself cause you problems on the spouse-based case. But, you know, every case is different. You got to look at the particular facts of the case. But generally, just having been denied a green card based on an insufficiency of evidence on an adoption-based green card case should not hurt you with a subsequent family, spouse-based, marriage-based I-130.
Okay. Will asks, if we get a new president, how quickly do you see the current immigration rules like public charge relaxing?
Well, that's something I've given a little bit of thought to. Now, number one, I don't want to get my hopes up because I believe, at least until recent developments in the election, I've been thinking that that the president would get reelected. It's still very likely that he's going to get reelected because there's a whole lot of white people that love Donald Trump. And so I think to overcome that is going to be difficult. But let's say that in November he loses and in January the new president comes in. I think it's January 18th is an inauguration day. I would imagine that just like President Obama and just like President Trump, that they would have a series of executive orders to sign the day that they take office. And so that's a method where they're undoing executive orders of the prior presidents. But an executive order can't overcome a new rule interpretation or a new regulation. So I think it would take a significant amount of time to undo the public charge rule. Now, everyone knows public charge is still in litigation, and the government could stop trying to defend the public charge rule. There's lots the president a new president could do if they were so inclined. And I do think a lot of the two Democrats that are left, I think that both of them would be inclined to try to stop that public charge interpretation, but there might be procedural hurdles that make that go slower than people like you and I would want to happen.
Okay. Ali said that his N400 application has been pending for review for 18 months. Should he sue?
So filing a lawsuit can be very helpful for a citizenship delay. And in honesty, it's actually better when you haven't had your interview than when you have. And what I mean by that? Well, there's a special rule for delays on citizenship cases. So generally, everybody should know, if they watch any of my stuff, that every agency, including USCIS or the State Department, that has a case in front of them has an obligation under the Administrative Procedures Act to decide a case before it within a, quote, reasonable amount of time. So there's a provision in the Administrative Procedures Act that says that we can go into federal court and ask a judge to compel them to decide a case. They can deny it, they can approve it, but they can't sit on it forever. So for all kinds of immigration cases, we can sue them for delay. For citizenship cases, there's a special provision called 8 U.S.C. 1447B. 8 U.S.C. 1447B says that if 120 days have gone by after your interview, that you can go into federal court and ask a judge to naturalize you or to send the case back to USCIS with instructions to finish your case in a set amount of time. That's a very powerful tool. The only downside of it is that you have to file those cases in the jurisdiction in which the N400 applicant lives. And so that makes it a little bit more difficult for me. I've been filing these in Memphis and in Pittsburgh and in other places around the country, but it's easier for me to file it in Washington, D.C. So if you haven't had your interview and we file a lawsuit, then typically within 2 months, they'll call me up or they'll call you up and they'll say, okay, we're finally ready to have your interview notice. If you did have your interview notice, then we have to file it in the federal jurisdiction in which you live, and then we go from there. And that's a little bit more problematic. We have to get sometimes local counsel to sponsor us and all this stuff. It's sort of a pain. Either one is fine, but waiting as long as he has, since when?
18 months. 18
months, that's plenty of time to sue, especially if more than 120 days have gone by since your interview.
Okay. Babir asks, he filed his N400, it was denied. Now he filed his N336 and got an interview less than 2 months. Will they only talk about the N336 or will they ask about the N400?
That's a good question, and I should make a video about that one. All right, so if your N400 is denied, you have one of two choices. One is you can walk away and then try to reapply at some future date. You can just let the denial go. Or you can file an N336. An N336 is an appeal, administrative appeal of a denied naturalization application. And what that means is you go down the hall and you talk to another officer. And the rules say that you get an administrative hearing within 6 months of the filing of the N336. Now, they don't always do that. And I've sued them for delays on N336s. But generally, you have the chance to go plead your case and explain why the N400 denial was in error. It's really interesting. In some cases, the jurisdiction, the local USCIS office treats these sort of as a joke, and they don't take them seriously. In fact, if you want to find a really funny video, it wasn't funny at the time, but it's funny now. I went to an N336 for a client of mine in Denver, and I got so mad because they refused to even consider the appeal that I shot this video outside their office just yelling and screaming about how terrible they were. So I sort of lost my mind. So if you want to see a crazy lawyer standing in Denver, go watch that video. But in any event, an N336, you're supposed to have that hearing, and the fact and what's supposed to happen is that they are supposed to ask you, what do you think we did wrong? You can submit a brief, you can submit evidence, you can show why they made a mistake and why the N400 was decided incorrectly. You can also supplement the record. So a lot of times with an N336, depending on which field office it is, they can take those seriously and let you submit more evidence, or even if they gave you a request for evidence at the N400 stage and you didn't submit any response or a timely response, some offices will even let you submit that at your hearing date or with your original N336 filing. So the N336, depending on the office, can be a joke or can be very helpful. And in a small number of cases, I have seen situations where the adjudicator uses the hearing at the N336 to try to find new reasons to deny the naturalization case. And they can do that. The rules allow that. So you don't have to take your test again. You don't have to take the English stuff, but you do have to be prepared to talk about any issue in your N400, because there are more than one immigration officers out there who sort of get off on these, and they sort of like trying to find other reasons. So they can say, all right, hacking, you and Mackenzie were right. We should not have denied Mackenzie's N400 case, but I found this other reason because I'm really clever, and she doesn't get her citizenship for that reason. So you got to sort of be ready for anything in these N336 hearings.
Okay.
Sorry you didn't get your citizenship.
Nassim asks, him and his family had an interview in 2012 and then 2016 and then one in 2017. They all got their visas, and there was a typo on his visa. He sent it back for correction, and they sent him the DS-5535.
Yeah.
He sent it back, and since then he's been in administrative processing.
Yeah, that was a bad move. I would just take the visa and go. You don't want to spend too much time going back and forth with them, asking them to fix the visa. It's something you can fix when you get here in the United States. As you can see, it's caused more problems, and then now they're just carping you. So how long ago did he file it?
Between 2012 and 2017.
Yeah, if you're still in admin processing for that long, you should definitely sue to get things moving. Otherwise, they're just going to keep screwing around with you. One point I want to make too is that a lot of people try to put a lot of stock in these online portals where you can talk to the embassy. I want you guys all to know that's BS. Like they don't see those. Those go into some invisible funnel that they look at every now and then. So nothing real is happening as you interact with the embassies through those online portals.
Sam wants to know, the daughter of his fiance who is coming on a K1 visa, does Sam have to adopt his fiance's daughter?
Say that again?
So Sam
has
a fiance who's coming on a K1 visa.
Yep.
His fiance has a daughter.
Yeah.
Should Sam adopt the daughter because he is the petitioner?
Well,
how does it affect the affidavit of support?
Okay, so that's a family question. That's not an immigration question. As a K1 beneficiary, the fiance can bring her daughter if we add her to the application. So it's possible for her to come, but that depends on whether or not you want her to come, whether the fiance wants her to come, and all that other stuff. But assuming that you do, you can do all that without adopting the child. The child can come to the United States, and then when you get married, they can get a green card based on that marriage without a formal adoption. As far as the affidavit of support, that's just one more person that you include in the calculus. So you would raise your income level by about $6,000 to account for that extra person.
Okay. Carla asks, will USCIS come after her green card at the citizenship interview if her and her spouse have lived apart for 5 months? They're still together and they've been married for 5 years. They just haven't been living together.
All right, so in this instance, Carla, I guess my main question would be, did you apply on the 3-year rule or the 5-year rule? Now, we posted a video, I think on Monday, on this topic, so go check it out, the difference between applying on the 3-year rule and the 5-year rule. And for those of you who don't know, generally a lawful permanent resident has 5 years to wait before they can apply for their citizenship. But if they are married to a U.S. citizen and have been married to the U.S. citizen for 3 years, then they can actually go ahead and apply after 3 years. So when you do that, though, you have to reprove the marriage. So, and USCIS has taken a strict scrutiny rule to naturalization applicants on the 3-year rule. And what I mean by that is that now you have to pretty much show that you've lived together as spouse and spouse, husband and wife, or wife and wife, or husband and husband, or and that you've lived together as a couple for every day of the full 3 years. So I believe it's an overly restrictive interpretation of the rule, but that's what they're doing lately. So if you're living apart and you applied on that 3-year rule, you might want to dismiss that case, wait 5 years, or if you're at the 5 years, dismiss and refiling. And in fact, I'm doing that right now for a guy from Arkansas.
Clayton asks, does public charge affect the lottery winners this year?
Yes, public charge affects lottery winners. Yes, it does. Here, I got one for you. Somebody asked a question. Have you dealt with on the Facebook? Have you dealt with divorce during 2-year conditional green card or 10-year one? Does USCIS scrutinize this? The answer to that is yes. So we have dealt with it, and yes, they do scrutinize it. So you need to be smart and careful with applying for a 10-year green card or applying for citizenship after divorce. They're starting to look at these more and more. And of course, the U.S. citizen sometimes has an incentive to say bad things about you. So you want to make sure that you do things the right way. And that's something we can help with.
Sebastian wants to know if his wife should bring a translator at the embassy in Santo Domingo or a lawyer, or is it possible to do it without both?
It is possible. They'll have a Spanish-speaking person there. I've never heard of a lawyer being allowed to attend an interview at the embassy, so you can forget about that. You could bring an interpreter, but there should be somebody there. Many of the officers will ask the questions in Spanish.
Vera wants to know if there are any news yet on the health insurance proclamation. The only thing she can find was the injunction issued in November.
Yeah, that injunction's still in place. I haven't, frankly, looked it up to see if anything's going. I'm sure I would have heard about it by now, but basically another little poison pill that little Nazi Stephen Miller and Trump came up with was that they were going to require immigrants to get health insurance before they could get a visa to come to the United States. And of course, it's impossible to get a visa. It's impossible to get someone added to your health insurance if they're not here and if they don't have a social security number. So that's on hold as far as I know.
Okay. Sue said a K1 couple for Jordan Embassy was denied after a writ of mandamus was filed due to the interviewer not yet deciding on the case. Therefore, they denied the lawsuit. How can that be?
That's BS. What does it say?
A K1 couple
in Jordan Embassy was denied after a writ of mandamus was filed due to the interviewer not yet deciding on the case. Therefore, they denied a writ of mandamus. How can that be? I think this sounds like third-party information. Generally, a writ of mandamus is not approved or denied. It's usually like, I'm not trying to see the judge. I'm not trying to make new law. So the idea that a writ is denied doesn't really work. Now, the judge might say, might say, although I've never had it happen, that someone hasn't waited long enough, or that, yeah, I can look that case up if you tell me who they are. I think it's very unlikely that what you've been told is 100% correct. I'm not saying anybody's lying. I'm just saying that it's probably confusing about that. They're probably just confused. So we probably have time for about 5 more minutes.
Okay. Kim said her husband had his interview in June 2019 in Morocco. The embassy called him to have her come into the embassy for an interview, and they separated them, and they're still waiting for a decision. What can they do?
Yeah, so that's what I was talking about, Kim, earlier, about how I'm really getting nervous about U.S. citizens being asked to attend interviews. I don't know from your text if you were asked to come to Morocco to go to the interview or if you were already in Morocco, but I've actually been telling people not to go to the home country because of this very concern. So I don't really recommend you doing that, but overall that can be a problem. So if you've been waiting that long, you probably should think about suing them, because as you know, that embassy in Morocco is the worst of the worst. I've sued them 70 plus times now, and so I think your case is stuck until then. Hold on, one of my old clients is listing questions here. I don't think you can see the private questions.
I can't.
Yeah, so let me scroll down to find his private question, because he's a good guy. And since he wants to remain private, I will not say his name, but he knows who he is because he's been a good friend of the firm and has been sending us cases for a long time. So let me find him. Man, there's some long questions. Dude, if you're going to, Oscar sent me a question that's about 3 pages long. Oscar, I can't answer a 3-page long question on a Skype call, on a webinar. Thank you. By the way, I forgot to tell everybody, I'm really tired. I haven't been getting sleep lately, so I apologize if I'm sort of loopy today. All right, here's my friend, my good buddy. All right, my man, what is the situation for a baby born outside of the United States from a green card holder parents who live temporarily outside of the United States? Oh, so that's a fun question. All right, so let's think this through. So mom and dad have green cards. Mom and dad go overseas and have a kid outside the United States. Well, first of all, my man, that's a bad idea. You should never do that because, of course, if the child is born in the United States, that child is a U.S. citizen. So this was a bad plan all along, and they shouldn't have done it. But now that it's happened, we will do our due diligence to try to figure out what the situation is. So if a child of a green, so I hate to say it, but I'm pretty sure that that child is going to have to file for an immigrant visa through one of the parents, and that the child is going to be stuck outside of the United States until such time as that green card is approved. Now, luckily, lately, I haven't checked lately, but the last couple months, the visas for the children of, green card holders have been immediately available because there hasn't been a backlog. But let me just make sure. So you guys, if you don't know about the visa bulletin, you should definitely spend some time with the visa bulletin. It's a good way to learn about all the different ways and hurdles that there are out there. Yeah, so the children of permanent residents, there's an immediate visa available. Those are current. That's F2A category. So you're still talking about having to process through USCIS and the embassy. So you're still talking about a year. And if the parents have green cards, they need to be worried about losing their citizenship. So one of the parents needs to come back. They both need to make sure that they don't spend more than 6 months solid outside the United States. They're gonna, or a year. If they stay out a year, they're gonna lose their green card. So this is a complicated situation, my man, and I suggest that they probably need help, and they need to be careful, and they need to not make any mistakes, because this is a real problem. Let's do one more. Pick a good one.
Abdullah asks, can you please explain the pros and cons of a fiance visa versus a spouse visa?
Oh, okay. First of all, number one, there's definitely tons of videos about fiance and spouse visas, why one is better than the other, on our YouTube channel. Now, for a fiance case, all you have to prove is that both couples are eligible to marry and that they intend to get married within 90 days of the arrival in the United States of the foreign national. Now, the foreign national who comes as a fiance will come faster to the United States. That's one little plus. Those cases are taking about 7 or 8 months at USCIS versus about 10 or 11 or 12 months on spouse cases. So fiance cases will come and they'll be a little bit faster. And of course, you don't have to actually get married. You just have to show that you've been in each other's physical presence at some point in the last 2 years. You have to prove that you've been on the same spot on Earth at some point in the 2 years before you apply. So that's the plus. Those are the pluses. It's also a little bit cheaper initially to do a fiance case and a little bit more expensive on the back end to get the green card. So if the marriage is if the relationship is 100%, the fiance case might be the way to go. Now, the downside of that is what's good about the spouse case. So what's good about the spouse case is it demonstrates a greater degree of seriousness with the relationship. They're generally approved more often. The embassies cause less mischief with a spouse case versus a fiance case. They are a little bit more expensive on the front end, but when the foreign national comes to the United States, in theory, that green card should follow them. So both have pluses or minuses. We have consults once or twice a week where people are, I'm living over here, my spouse or fiance is living over here. We want to have a wedding in Florida on this day, but we have a big marriage celebration scheduled in Italy for the rest of the family here. I have a job, he has a job, we're doing all, there's always these moving parts. So I would say, in answer to that question, figure out what works for your life best, and then do the family based petition if it's a spouse, whatever works best. There's more ways to get you here than those. If the person can get a visit visa to the United States or come as a student, those are always options, but those are tricky, so you got to be careful, and you can't have immigrant intent. But there's more than one way to skin the cat, and you need to be thoughtful, and you need to make sure that you do things right, but you should be able to pull off what you want to pull off so that it tracks what's good for your life. All right?
Last one?
You got one, or I have one more? That's it.
I do have one.
Okay, Mackenzie has one more, and then we'll finish up.
So Richard said that he had an N-400 interview based on the marriage with an I-751 pending.
Yeah.
The officer started with the I-751 and was not convinced by the documents submitted. She said that he would get a notice by mail in 2 weeks and wished him a good day. On his USCIS account online, it says the N-400 interview was canceled.
Did he get the test? Did he get tested?
I don't. He doesn't say.
Richard, let us know if you got tested in there on Facebook. This is our last question, but generally, man, there's a lot of comments. Generally, if you, so the 751s used to take 2 or 3 months to get approved. Now they take 18 months. So initially we were telling people to go ahead and file for naturalization to try to push the 751 along, but it's been a disaster. Not that our clients' cases have gotten denied, it's just that USCIS for some reason can't get their act together, and when a 751 shows up without the N-400, or if the N-400 shows up before the 751, all hell breaks loose and they get all confused and they don't know what to do. So in your situation, when was the 751 when was the interview?
I don't think he said.
Yeah, so if you've been waiting months and months, it's probably garbled up. If you didn't use an attorney, it's probably garbled up. If they didn't conduct your N-400 interview and testing, it's probably garbled up, and you might need to sue them. So that case sounds a little bit messy. Not your fault, it's their fault, but the result is the same, which is that your case is stuck. So I'm sorry about that. All right, so we're going to go ahead and wrap up. We thank everybody. We had 75 people between the webinar and Facebook, which is pretty incredible. I like doing these things. And we'll do them again in a couple weeks. We'll send out a notice. You should all get a copy of this webinar, and maybe next time we can have people submit questions ahead of time too. That might be good. Yeah. That way it's not such a frenzy, and we'll do what we can on our end to figure out what the heck was wrong with that sound thing. But I'll keep these little donkey headsets. They save the day. I got these like at the gym for free, so somehow I saved them, and that's what was able to allow us to record this crazy webinar. Everybody, if you have questions or if you need to get a hold of us, you know the drill. I say it at the end of every video. You can email us at info@hackinglawpractice.com. You can call us at 314-961-8200. Be sure to join us in our Facebook group, which is called Immigrant Home. We have a lot of good discussions there. We have 30 people watching the webinar right now in there. And be sure to subscribe to our YouTube channel. We're getting tons of subscribers every day. We're trying to hit a number, trying to get 1,000 subscribers within 30 days. That would be something. So if you know anybody who needs this kind of advice and you want to share it out there, you want to say thanks to us, that would be great. One last thing, if you think this video was helpful, and I hope you did, or if you have ideas on how we can improve it, let us know that. But if you want to leave us a review on Google or Facebook, it's a big help to us. Even though we're not your attorneys, you can still say that you found us helpful, that our information is instructive, and so we really live and die on those Google reviews and those Facebook reviews. So if you guys want to do me a favor, we would greatly appreciate it. Thanks a lot, everybody, and we'll see you next time. Peace out. All right, so red phone there.